Thank you. Senator from Charleston, Senator Senn, what purpose do you rise?
To see if the senator would yield for a few questions.
Yield to my friend.
Senator yields.
Thank you. So this is just in follow-up to our colleague from the senator from Orangeburg. You indicated that these products couldn't be done in public, such as on a bus or things of that nature, but this bill would allow the vaping of marijuana, right?
It does.
Okay, so we can't tell when someone's vaping. It's happening in schools. We don't know what they're vaping. So technically, yes, you could be in a car, on a bus, whatever, and law enforcement's not going to be able to determine what's in your vape.
Yeah, I'm not naive enough to think that simply because something is prescribed in this law that some people aren't going to break the law. I mean, I think that's true of whatever we choose to criminalize. There's always going to be people that don't follow the law. I can't dispute that, Senator.
Right. And you know the laws change over the years in the states that have passed it. For instance, I went to Heavenly Ski Resort last week. I'd been there many times before, and I don't know if you've ever been there, but did you know that this year, right by the bathrooms where you go skiing on the ski slopes and the hot chocolate for the kids and the soup bar and all of that, there is a roped off big pot leaf for people to come over and smoke on the ski slopes that hadn't been there before. So do you know if these laws change and get progressively easier for people to do that type of stuff in public in the states that have legalized it?
I guess my response would be, and I don't know if I was answering your question yesterday about that, but whether or not a law progresses from medical to something more depends upon the citizenry, right? Because we're all members of the Senate and we represent about 115,000 South Carolinians. You got 124 House members that represent their constituents. And if laws change, either to make it tighter or to make it more liberal, it's by and large going to be a reflection of what those constituents want. And so I would take exception with the fact that because they may have progressed in Colorado or California, that it's going to progress here. The people of South Carolina are different than the people of Colorado and California. And so ultimately, I can't predict, and neither can you or nobody else can predict whether this law, if it's passed, would get more restrictive over time or less restrictive over time. It depends upon what the people of South Carolina want, because we represent their interests. And I'd be amazed if this General Assembly, simply because other states have authorized adult or recreational use, that somehow means we're inexorably going to do the same. I know this chamber and I know that chamber, and that ain't going to happen. And so I think it's dangerous to generalize by comparing what has happened in what are more socially liberal states with what's likely to happen in South Carolina.
Thank you, Senator. May I hit upon two other points just following up to the Senator from Orangeburg?
Absolutely.
Y'all discussed seizures, and there was a person that apparently contacted his office. I bet I can guess who that person is. But then we have, I'm sure you've seen that Representative McCoy, who's no longer in the House of Representatives, he was a big sponsor over on the House side. And he had a child that had some seizure issues. Isn't it true that the seizure issues, by and large, get resolved with CBD oil? Yeah. We've already passed that.
Yeah, I think it depends on what the underlying reason for the seizures are. I think that you're right in the epilepsy context that predominantly the CBD derivative of cannabis is what's used to address that. But what I would also say is, in looking at what the Epilepsy Foundation and others have said, in a lot of patients, CBD may be the active component, but THC is an accelerant and helps it work its way through the body more effectively. So I would say that in many instances, even though CBD may be the predominant thing that addresses the seizures, that working together with THC, you get better results. And that's, again, that's what the medical research shows. I can get into some of that later on. But to your point, by and large, as a general rule, CBD is the thing that has really helped epilepsy patients in particular.
Right, and the senator from Orangeburg didn't address this, but just while we're sort of on that issue, I know you may have mentioned it yesterday, but we already passed, I wasn't in the General Assembly at the time, a right to life statute, I believe.
Right to try.
That's a right to try. So folks who can be, I guess, assumed by a doctor, the doctor's going to say is end of life within a year, they already can participate in any one of hundreds of trials, medical trials, and get marijuana for free, basically.
Yeah, and one of the points of departure for me in this bill was to kind of build on what we did in Right to Try. Because if you look at Right to Try, what a physician has to certify in order to access these non-FDA drugs is that traditional, regular therapeutics or pharmaceuticals have not provided the relief, okay? And so that's why that was built into this bill in terms of what a physician has to certify. And you can't just walk in and say, I have pain, and you get a medical cannabis authorization. The doctor has to go through in an in-person diagnosis and determine that regular pharmaceuticals or regular FDA drugs have not worked, okay? So this bill is set up along the lines of that Right to Try as sort of a last resort, when these other things that you have tried haven't provided the relief, and that's when you get to the certification by the doctor that medical cannabis can be authorized. So it's very similar to Right to Try in that way.
Okay, so, and I've heard you, and I believe you honestly believe that, that the doctors are really going to have great input to make sure that these card holders are, you know, seriously in pain and debilitating type illnesses. But it's true in other states that sometimes the doctor's offices are right there within the pot shops, right? Okay. In fact, go ahead.
There have been examples in other states where the doctor or physician authorization requirement has been a joke, where you just simply drive by, you check in, you get your written authorization, you're out the door. Okay, I'm familiar with that, which is why we took such great care in this bill, and I'll get to it in a moment in its proper section, to really outline what a physician has to do in that inpatient diagnosis process. And I'll represent to the body without equivocation, it is more thorough, more onerous, a higher degree of due diligence than any other state has. And that's what I want, because what I ultimately want is for that physician and that patient to be the ones that decide upon what's best for that patient. And I want that physician to know there's got to be this honest conversation in regard to all of these things, particularly in regard to, does the patient have a history of psychological disorders or schizophrenia? Because as has been demonstrated in this book that I held up yesterday, it isn't good, it's not the right thing for some patients. It's not a panacea. And in some cases, it could be dangerous, and in some cases, it could be detrimental. But that's the whole reason why this bill is so heavy on that physician diagnosis and that physician consultation, for that very reason.
Senator, and I believe in your heart you truly believe that, but I do wonder, do you think that the same doctors who currently are loose with their prescriptions might be loose with medical marijuana need diagnosis?
I don't. First of all, I'll give you a few reasons why. It has to be a physician who's authorizing in an area of their expertise. Okay, so it can't just be any doctor. It's got to be a physician.
A pain management doctor can do it all.
This is their area. But the penalties that would accrue to a physician if the physician did not honor that written certification, and it's a very detailed written certification. The Board of Medical Examiners, and the bill also provides for that, has plenary disciplinary authority in regard to physicians who do not follow these protocols. And so, I mean, look, I can't speak to physicians and what they might do. I can just say that, you know, it's almost like a lawyer. I mean, a lawyer is not supposed to embezzle funds. You could get disbarred. The South Carolina Bar is going to, you know, suspend you. Does that mean that there are some lawyers that will embezzle? Does that mean that there will never be lawyers that embezzle funds? No, because they do. They do. So I can't say to you, simply because we have these requirements in the bill, that there aren't going to be physicians that take shortcuts. What I can say to you is there are severe penalties if they do so.
I don't see anywhere in your bill that would prevent a doctor from say, okay, look, we're going to have all these dispensaries. I'm going to come in and buy and set up shop right next door. Is there anything in your bill that would prevent that?
Well, first of all, there's a direct prohibition from a physician having any financial interest or pecuniary interest in a dispensary. I'll need to go back and look at the bill to see whether or not there is a requirement that they don't be in the same facility.
Yeah, there is, that's in there, but just not that they can't just open up right next door.
Okay, well,
Okay.
That's what the bill says.
And then finally, to Senator from Orangeburg's point regarding law enforcement and the ability for us to arrest and properly convict those who have had too much alcohol. We simply cannot do that with marijuana. I think you've already said that, unless we get a blood draw. Same thing with opiates.
No, but even with the blood draw, I think the point that the senator from Orangeburg was making is THC remains in your system sometimes for weeks. Okay, so I think the point that he was making was, even in instances where you did a blood draw and there were amounts of THC, you cannot reasonably infer from that presence of the THC was the result of some sort of an impairment while driving. It's just a different, it breaks down much more slowly in your system than alcohol does. But what I would say is that same problem in regard to assessing whether or not somebody under a prescription drugs is driving impaired, those same restrictions hold. And what I'm saying is the fact that it's the fact that you can't measure it the same way you do blood alcohol isn't a reason not to pass this bill. If it were, it'd be a reason to do away with all these other medicines for which you can't determine the levels when somebody's driving impaired. And then the second point I would make is there are these field tests, these field sobriety tests, that even in cases of alcohol, if somebody doesn't want to take or blow the breathalyzer, they take them out there and they prosecute cases based on what that field test is, right? So it's not like, it's not like they're not doing it already, but I frankly acknowledge you don't have that blood alcohol level tool with cannabis. We just don't yet.
I agree with you, sir, about the level of THC, because it can stay in the system for like a month.
Right.
However, there's a derivative that can be tested if you get a blood draw. And the same thing with opiates or other illegal stuff that can be detected, you can get a blood draw. Are you aware that other states have now had to fund phlebotomists so that they can take blood alcohol roadside? Utah being one, there are others, but have you factored that in to potentially the expense?
Well, in terms of the expense, in the case of every state that has medical cannabis laws, the revenue that is derived from it in every instance has been in excess of the cost to administer the program. So if anything, this is going to be a revenue enhancer. But to your point, if there are tests like that now, if there are blood tests like that now, that are properly and fairly determinative of somebody's level of impairment, I'll be happy to look at an amendment in that regard and to factor that into the fiscal impact.
Yes, sir.
Because I want this bill to be as tight and as regulated as possible. And I readily admit that although I've worked on this for 7 years, there are things that I haven't emphasized that I should. The primary example being the pharmacist being the one to dispense. Until I took this well yesterday and heard from the senator from Charleston and the senator from Greenville, and the senator from Spartanburg as well, Senator Kimbrell, I didn't understand the depth of how important that was to have that degree of expertise there. So if there is some things that you're aware of because you are more involved in law enforcement than I am, I would welcome your expertise on that.
Okay, we'll do. Interestingly, though, you brought up the fact that the revenue raised generally is going to outstrip any type of deficit. Mm-hmm. Is it true that any revenue generator bill should originate in the House?
Not if it's an ancillary thing to the underlying bill. And I've researched this and talked about it with the clerk in drafting this bill. And the fact that there is a sales tax component that's designated to defray the cost of this program, it does not make it non-germane or does not subject a point of order because it's ancillary to the overriding intent of the bill.
No, I'm not talking about it being germane. I'm talking about the Constitution of South Carolina says any revenue fundraiser is supposed to originate in the House.
I don't think that's the proper reading of that constitutional provision. I think it has to do with whether or not a bill's intent is primarily a fundraising. That's my understanding. And in any event, the constitutionality of it isn't something that we should discuss right here, right now.
I'm not trying to raise a point of order now. I certainly want you to go ahead and have a full and fair opportunity given your great and detailed work on this issue. But I was just wondering if you knew the answer to that question and figured that you would. You also mentioned, though, that in other states, the revenues are so high and therefore, like you said, outstrip any type of deficit. But are you aware that in Colorado, both the governor and the bill's sponsor both greatly regret their effort to get marijuana into their areas, saying that they highly underestimated the black market? Because we will tax these things. I certainly will vote to tax it at every turn. Whereas the black market general pot dealers, they do not. And therefore, it would be a lot easier, to go on into other states and get people that are going to make brownies, are going to make cookies. I know you can't do regular pot under your bill. It would be very easy just to go to the black market on that, wouldn't it?
Yeah, and did you know that those comments were made by them in the context of recreational use of marijuana, not medical? And I think that's always an important point for us to make here, because you can throw out some statistics in regard to what the experiences of other states have been, recreational states, okay? I'm not defending the recreational or adult use of marijuana. And I would argue that it is not relevant or instructive to our debate here to look at what the experiences of states that have legalized it for adult use should be in regard to our very limited medical cannabis use. I think a more instructive thing to do is comparing it with other states that have had medical cannabis laws only, and to look at what the data in those areas show us in regard to use.
I agree with you, and that's to go to Senator Cash's point. In fact, I went over and mentioned to him that I continue to use Arizona as an example, because they, like the other states that have followed the playbook, they go first to medical use, then they add different ailments that can be considered, part of what they can use for medical use, and then they end up often in recreational. I used Arizona because they just recently, in fact, probably while I was out there, because, Tahoe's in the middle of California and Arizona. Oh, no, that's Nevada. But I used Arizona because they just recently went recreational, I believe it is, and the 2021 data that I was using was prior to that implementation. Also, did you know, Senator, that...
Can I respond to that?
Yes.
Again, it depends upon the citizenry of the state that you're talking about, okay? Arizonans aren't South Carolinians. South Carolinians aren't Californians. I mean, ultimately, the laws that we pass and the laws that we put in that code are reflective of what we as a General Assembly think are best representative of what the people of South Carolina want. So again, there are going to be some states that demographically are just more socially liberal than others. I would submit to you, South Carolina isn't that state. And again, I can't predict what the future holds. What I can say is, I think that House members and Senate members are going to vote in their constituents' best interests. And knowing South Carolinians like I do, I just don't, there's not some inexorable force that's out there, extra legislative, that makes us do things like we're automatons in here to go ahead and do recreational because we passed medical. That's just not the way things work.
And I understand that, and I accept that point. But I would like to talk more about the statistics with Arizona, because did you know that a lot of the states that have legalized marijuana did not, or for medical use, did not mandate that their state keep statistics of what the ailments were that the card applications were given? And Arizona did. A lot of the other states were voluntary, so you're looking at voluntary data, which to me you may as well throw out of the room. But for the states that have mandated that the physicians say why they are going to be giving this card to somebody, that would be important, don't you think, to see if we have some real data as far as ages of people doing this and what they're doing it for?
I think it's important to have that data. And again, I think what you're alluding to is the prevalence for applicants in Arizona getting it for chronic pain. And again...
And they're young.
Well, no, let's go through those statistics again,
well,
because
again,
that's just not true. I mean, all right, so there's 24.5% 18 to 30. There is 21% of 41 to 50. There is 15% 51 to 60. There is 15.5% 65 to 70. 5.4% 71 to 80, and little less than 1% for 81 plus. So this statement that a majority of them are predominantly young, I mean, the percentage of individuals under 50 is only 45%. The percentage of individuals under 30 is 24%. So that's just not a correct statement.
Well, you're looking at a handwritten note that you're taking from somewhere, so maybe you and I can.
I'm taking it from, and it's on my phone that's getting charged over there. It's a screenshot from the Arizona state government website telling us who the users are and what their age groups are.
So maybe you and I'll get together after,
Sure.
and we'll compare to make sure we're looking at the same data.
Happy to do it.
Okay, and then last, I just want to go back to the Senator from Orangeburg's questions when we're talking about blood draws and things of that nature. Our officers, sure, they can do field sobriety tests, and this is going to be another issue that comes into play. They can do field sobriety tests all day long, but as a lawyer who regularly is in trial and dealing with stuff like this, it's very difficult to convict anybody if you don't have a camera rolling on that field sobriety test. And as we know, we have not properly funded cameras yet. Period. So there are a lot of agencies that it's going to be the officer's word versus, a video camera of the person stumbling and not walking correctly. So, and then again, sure.
Finish that thought. Since we're talking about the area of traffic safety and impaired driving, and I don't know if you were here yesterday when I had this conversation, that there are 7 different studies, including one by the Department of Transportation, that have taken place over as long as a period of 20 years. And there is a direct correlation between authorizing cannabis for medical purposes and a decrease in overall impaired driving. And did you know that and you're smiling because it sounds counterintuitive, but again, we have experience of states that have passed medical marijuana laws, and the DOT goes into explaining why this is the case, because in many instances, marijuana and alcohol are seen as substitute goods. And empirically, and the data shows that somebody who's getting behind the wheel driving with alcohol is much more reckless, much more likely to be unaware of their impaired condition than somebody who is operating on the influence of cannabis. That is not an argument in favor of getting high and driving a car. It is a statement of fact that if you're worried about fatalities, if you're worried about impaired driving, these studies comprehensively show that states that have authorized medical use, you've seen the number of those impaired driving cases go down. Okay? And so that's, anyway, I just want to make that point.
I was smiling because I have data indicating the direct opposite. So maybe so that for the benefit of the body, you and I can compare those notes so we can come to some type of agreement perhaps. But my question is, are you aware that officers often cannot convict, even if it's an alcohol situation, if they don't have a blood alcohol? And in fact, we go ahead and we say you're not going to have your license if you're not going to go ahead and submit to test. Your bill also says if someone pulled over suspected of being on marijuana and high from marijuana, that they can have some type, I guess their card revoked. There'll be some restriction or penalty on them for failing to take the test. Would that include, though, a blood draw?
Not in this bill, no. And the reason for that is, Senator from Charleston, is a blood draw right now, at least my information isn't going to give you any meaningful information because THC can remain in your system for a long time, and the presence of THC in your system may not be probative of whether or not you're driving impaired for that reason.
There are metabolites that are different, but so you and I'll talk about that over the weekend too. Thank you, sir.
But anything, I mean, and let me say this, kind of button this up, anything that you can propose that empowers our law enforcement officials at that level to make these determinations and to prosecute successfully people who are driving impaired, I'm open to receiving.
I understand. You've been very open for everything. Thank you, sir.
Yes, ma'am.